Anti-gun judges across America have been playing the same tired game for months now, claiming they're totally baffled by Supreme Court rulings on gun rights, and throwing their hands up like confused school children whenever a Second Amendment case hits their desk. But here's what they didn't see coming. SCOTUS just dropped a legal bomb that's about to make their fake confusion routine completely worthless. Before we break down exactly how the Supreme Court just checkmated every anti-gun judge in the country, smash that subscribe button and hit the bell so you never miss when we expose the left's latest schemes backfiring in real time. Case introduction and surface-level explanation. The case that just shattered the anti-gun playbook doesn't even mention firearms once in its title. It's called Health and Hospital Corporation of Marion County versus Talevski. And on paper, it looks like another boring healthcare lawsuit that only lawyers could love. An elderly man in Indiana claimed a county-run nursing facility violated his rights under federal Medicaid law, and his family sued for damages. The facility fought back, arguing that patients and families have no right to sue under Section 1983 of federal civil rights law when Medicaid standards get violated. Sounds about as exciting as watching paint dry, right? The Supreme Court just used this seemingly mundane case to deliver a masterclass in how they handle whining from lower courts, and the implications for gun rights are absolutely massive. The justices ruled 7-2 that, yes, patients can sue under Section 1983 when their Medicaid rights get trampled. But the real fireworks came in how they explained their reasoning. Justice Breyer wrote the majority opinion like he was explaining basic math to kindergartners, leaving zero wiggle room for future judicial theatrics about being baffled by clear legal standards. Deep dive legal analysis. Here's where this gets absolutely devastating for the anti-gun crowd. The Supreme Court laid out a crystal clear framework for when federal laws create enforceable rights. The court established that when Congress uses mandatory language like shall or must in federal statutes, and when those statutes focus on the people protected rather than just the institutions regulated, then individuals have the right to sue when those laws get violated. This is legal dynamite because it's exactly the same reasoning that applies to Second Amendment cases where anti-gun states try to ignore federal constitutional protections. Justice Thomas wrote a separate opinion that was even more brutal, essentially calling out lower courts for their bad faith interpretations and reminding them that federal law means what it says, not what progressive judges wish it said. The parallels to gun rights litigation are impossible to ignore, especially when you consider how anti-gun judges have been playing the confusion game since the Bruin decision. For the past 2 years, federal judges in California have literally written in their opinions that they lack the expertise to analyze historical firearms regulations, while judges in New York have complained that the historical record is too complex for modern courts to navigate. Pattern recognition and anti-gun strategy backfire. This is where the anti-gun strategy completely falls apart, and the timing couldn't be more perfect for gun rights advocates nationwide. Over the past 18 months, we've seen a coordinated campaign from anti-gun judges to undermine the Bruin standard by claiming historical analysis is beyond their capabilities. Judge Roger Benitez in California wrote a 90-page opinion striking down the state's assault weapons ban, only to have the Ninth Circuit reverse him, partly based on claims that the historical analysis was too speculative. Judge Catherine Polk-Failla in New York dismissed a challenge to the state's concealed carry restrictions by arguing that founding-era firearms regulations were too dissimilar to modern laws to provide meaningful guidance. The beautiful irony is that every one of these confusion claims is now evidence for why the Supreme Court needs to take more gun cases, not fewer. The Talevski decision shows that when lower courts claim they can't apply Supreme Court precedents, the justices don't respond by watering down those precedents. They respond by making them even clearer and more binding. Justice Barrett's concurring opinion specifically noted that the court's job is to provide guidance when lower courts struggle with federal law interpretation, essentially inviting more appeals from confused judges. Supreme Court's message to activist judges. The most devastating part of this ruling is how the Supreme Court essentially called out every activist judge by name, without actually naming them. Justice Alito's concurrence included language that legal experts are calling a judicial smackdown. He wrote that federal courts have been analyzing complex statutory schemes and historical precedents for over 200 years without issue. The message is crystal clear. If you suddenly can't do basic legal analysis when gun rights are involved, you're either incompetent or acting in bad faith. Chief Justice Roberts added his own pointed commentary about how federal judges are supposed to be the nation's most qualified legal minds, not helpless children who need constant hand-holding from the Supreme Court. The court even referenced specific examples of complex historical analysis that lower courts handle routinely in other areas of law, making it impossible for judges to claim they lack the skills for Second Amendment cases. Justice Gorsuch's separate opinion was particularly brutal, noting that courts regularly interpret 18th century contract law, property disputes, and maritime regulations without claiming confusion. Financial consequences for anti-gun states. Here's something the mainstream media won't tell you. This decision is about to cost anti-gun states millions of dollars in legal fees and damages. Under Section 1983, the same law clarified in Tlevsky. Winning plaintiffs in civil rights cases can recover attorney fees from the government defendants who violated their rights. Gun rights organizations have been keeping detailed records of every case where judges claimed confusion about Bruen. And those records are now roadmaps for massive fee awards when those cases get overturned. California alone has spent over $50 million defending gun control laws in federal court since 2022, and that number is about to skyrocket as their losing streak accelerates. New York's Legal Defense Fund for gun cases has already exceeded $30 million, and state budget documents show they're preparing for significantly higher costs in 2024. Illinois just allocated $25 million specifically for defending their assault weapons ban, money that's essentially guaranteed to be wasted now that judicial confusion is no longer a viable defense strategy. Media blackout and information control. The mainstream media's coverage of this case perfectly illustrates how the anti-gun establishment controls information to keep gun owners in the dark about their victories. CNN covered the Tlevsky decision with exactly 47 words in a brief legal roundup, focusing entirely on the healthcare angle while completely ignoring the implications for constitutional rights. MSNBC didn't mention the case at all, despite spending hours that same week complaining about extremist Supreme Court gun rulings. The Washington Post buried their coverage in the legal section with a headline that made it sound like a minor procedural update rather than a game-changing precedent. Meanwhile, anti-gun legal organizations like the Giffords Law Center sent out fundraising emails that same day claiming the Supreme Court was retreating on gun rights, a complete fabrication designed to keep their donors confused and angry. This information blackout isn't accidental. The anti-gun lobby knows that informed gun owners are effective gun owners, so they work overtime to keep us from understanding how much we're actually winning. What this means for future gun cases. The ripple effects of this decision are already being felt in courtrooms across America, and gun rights lawyers are updating their strategies accordingly. The Second Amendment Foundation has announced they're filing 3 new federal lawsuits specifically designed to test whether judges will continue claiming confusion now that the Supreme Court has made their expectations crystal clear. Gun Owners of America is preparing to appeal every single case where a judge cited historical uncertainty as grounds for dismissal, using Tlevsky as the primary precedent for reversal. The Firearms Policy Coalition has identified 47 pending cases where district judges used some variation of the "we're too confused" excuse. Every time anti-gun judges whine about not being able to apply Bruen, they risk handing the Supreme Court another excuse to step in and hammer down a ruling that leaves zero room for gun control gymnastics. The Tlevsky decision showed us exactly how that plays out. Confusion gets met with clarification. and clarification always favors constitutional rights over government power. Do you think judges are genuinely confused, or is this all part of a bigger delay strategy? Drop your answers in the comments, then hit like, share this with your crew, subscribe, and click the bell.